Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in Koons versus United States, certiorari to the United States Court of Appeals for the 8th Circuit. Argued March 27, 2018. Decided June 4, 2018. The 5 petitioners pled guilty to drug conspiracy charges that subjected them to mandatory minimum sentences under 21 U.S.C. 841b1. Before imposing their sentences, the district court calculated their advisory guidelines ranges. But because the top end of the guidelines ranges fell below the mandatory minimums, the court concluded that the mandatory minimums superseded the guidelines ranges. After discarding these ranges, the court departed downward from the mandatory minimums under 18 U.S.C. 3553E to reflect petitioners' substantial assistance to the government in prosecuting other drug offenders. In settling on the final sentences, the court considered the relevant substantial assistance factors set out in the guidelines, but it did not consider the original guidelines ranges that it had earlier discarded. After petitioners were sentenced, the Sentencing Commission amended the guidelines and reduced the base offense levels for certain drug offenses, including those for which the petitioners were convicted. Petitioners sought sentence reductions under 3582C2, which makes defendants eligible if they were sentenced based on a sentencing range. That was later lowered by the Sentencing Commission. The courts below held that petitioners were not eligible because they could not show the sentences were based on the now lowered guideline ranges. The Supreme Court held petitioners do not qualify for sentence reductions under 3582C2 because their sentences were not based on their lowered guideline ranges, but instead were based on their mandatory minimums and on their substantial assistance to the government. For a sentence to be based on a lowered guideline range, the range must have at least played a relevant part in the framework the sentencing judge used in imposing the sentence. See Hughes versus United States. That's an opinion that just came out today. Petitioners' sentences do not fall into this category because the district court did not consider the guideline ranges in imposing its ultimate sentences. On the contrary, the court scrapped the ranges in favor of the mandatory minimums and never considered the ranges again. Thus, petitioners may not receive 3582C2 sentence reductions. Petitioners' 4 counter-arguments are unavailing. First, they insist that because this court has said that the guideline ranges serve as the starting point for every sentencing calculation in the federal system, CPU versus United States, all sentences are based on guidelines ranges. But that does not follow. Just because district courts routinely calculate defendants' guideline ranges does not mean that any sentence subsequently imposed must be regarded as based on a guidelines range. What matters instead is the role that the guidelines range played in the selection of the sentence eventually imposed. And here, the ranges played no relevant role. Second, petitioners argue that even if their sentences were actually based on the guidelines ranges, even if their sentences were not actually based on the guideline ranges, they are eligible under 3582C2 because their sentences should have been based on the guidelines ranges. But even assuming that this is the correct interpretation of based on, petitioners are not eligible because the district court made no mistake in sentencing them. The court properly discarded their guidelines ranges and permissibly considered only factors related to substantial assistance when departing downward. Third, petitioners stress that the Sentencing Commission's policy statement shows that defendants in their shoes should be eligible for sentence reductions. Policy statements, however, cannot make defendants eligible when 3582C2 makes them ineligible. Fourth, petitioners contend that the court's rule creates unjustifiable sentencing disparities, but in fact the rule avoids such disparities. Identically situated defendants sentenced today may receive the same sentences petitioners received, and those defendants like petitioners, are not eligible for sentence reductions under 3582C2. The lower court's decision is affirmed. Justice Alito delivered the opinion for a unanimous court. Thank you for listening.